Good day everyone. So today we're wrapping up the week 4 presentation and we'll cover the topics for week 5, pure and conditional obligation under the Civil Code. So let's begin with the basic of the law. Article 1179. So it says every obligation whose performance does not depend upon a future and or on a certain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a salutary condition shall also be demandable without prejudice to the effects of the happening of the event. In simple terms, this article distinguishes obligation that can be demanded immediately from those whose effect depends on a condition. So, pure obligation. A pure obligation is one that is not subject to any condition and has no specific date for its fulfillment. Because there is no condition or period, it is immediately demandable. For example, T obligates himself to pay C 1,000 pesos because no condition or date is stated. C demanded payment immediately. So sometimes, although a period may be intended by the parties, if it is not stated, courts can determine a reasonable period based on the nature of the obligation. So for conditional obligation is one whose consequence depends on fulfillment of a condition. In other words, the effectivity or termination of the obligation hangs on the event that is either future or uncertain or past but unknown to the parties. So what is condition? Condition is a failure, is a future and uncertain event upon which the acquisitions or extinguishment of an obligation depends. Conditions have two main characteristics. First, one is they related to the future and uncertain event, or second, they may refer to a past event unknown to the parties. A condition must also be possible if it is impossible, illegal, or contrary to public policies. The obligations depending on it may be void. Two principal kinds of conditions. The first, suspensive conditions, also called condition precedent. This is when obligation becomes demandable only after a certain event occurs. Example, I will sell you the land if it's adjudicated to me in the division of my deceased father's estate. Here, my obligation to sell arises only after the conditions becoming the owner is fulfilled. Casual and mixed conditions. A casual condition depends on chance or on the will of a third person, not the debtor. For example, S binds himself to sell his land to B if he wins a case pending before the Supreme Court. A mixed condition depends partly on a chance and partly on a third person. These are valid as long as the condition is not left solely to the debtor's will. Impossible conditions. Article 1183 tells us impossible conditions annul the obligation which depends upon them. They can be physically impossible, like I'll pay you 10,000 pesos if it does not rain for 1 year in the Philippines. And legally impossible is like I'll give you 1,000 pesos if you kill someone or if you don't act against law or morals. However, if the condition is negative, meaning not to do an impossible thing, it is disregarded and the obligation becomes pure. Also, the obligation is divisible. The valid parts remain even if one condition is impossible. Positive conditions that determine time. Article 1184 refer to positive conditions, the happening of an event at undetermined time. An obligation is extinguished as soon as the time expires without the event taking place, or as soon as it becomes clear that the event will not happen even if the time has not expired. So, for understanding these concepts help us see when obligations arise, when they can be enforced, and when they will end.
Good day everyone, I'm Hanilyn Vargas, and for today, I would like to tackle about the Article 1186, Article 1187, Article 1188, and lastly, we have the Article 1189. So first, let's proceed to the first one. Article 1186, which is the constructive fulfillment. So Article 1186 tells us that the condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. So what does it mean? So basically, if the obligor or the one who was the duty purposely does something to stop the condition from happening, the law pretends that the condition has already been fulfilled. So there are three requisites here. The first one we have is the condition must be suspensive. So meaning, the obligation will only take effect once the condition happens. Number two, the obligor prevents the fulfillment of that condition. Number three, the act of prevention is voluntary and it doesn't even have to be malicious or fraudulent. The purpose is to stop the condition. The law is fair here because it doesn't allow anyone to profit from their own wrongdoing. So, for example, if X promises Y a 5% commission, and if Y sells his land at a certain price, and then Y finds a buyer, but X himself sells directly to that buyer just to avoid paying commission, the law considers the condition fulfilled. X still owes Y the commission. So another example here is S promises to sell his land to Y if Y can secure a bank loan. But then S convinces the bank not to give Y the loan. Then the condition is also considered fulfilled. So in short, Article 1186 is about constructive fulfillment. The law steps in to protect the obligee and prevent the obligor from taking advantage of its own actions. Now, let's move on to Article 1187. This one is about the retroactive effects of a condition once it is fulfilled. The rule here is when a suspensive condition is fulfilled, its effects go back to the day the obligation was constituted, not the day the condition was actually fulfilled. Why? Because a condition is only an accidental element of a contract. The obligation is already there. It's just, suspended. So if the condition happens, we treat it as if it was effective from the very beginning. So how does this apply? One is in obligations to give. So if the obligations are reciprocal, then the fruits and interest during the waiting period are considered mutually compensated. So this avoids complicated accounting. If the obligation is unilateral, usually the debtor keeps the fruits and interest unless there's proof that the parties intended otherwise. We have number 2. In obligations to do or not to do. So here, the law gives flexibility. The courts decide whether the effect should retroact or not, depending on the nature of the obligation and the intent of the parties. So for example, let's say S agrees to sell his land to B for 50,000 if B loses a case. Later, B loses the case. So legally, it's as if the obligation existed from the day they made the agreement, not just on the day B lost. So the right of B retroacts to the very beginning. So the main point of Article 1187 is once the condition is met, the obligation takes effect as if it was already valid from day one. Now, what happens while we're still waiting for the condition to happen? That's what Article 1188 talks about, which is the rights pending fulfillment. So it gives rights to both the creditor and the debtor while the condition is pending. So on the part of the creditor, he can already take actions to preserve his rights. So for example, if the obligation involves a piece of land, the creditor can ask the court to annotate his rights in the title so that the debtor won't secretly sell it. Basically, the creditor doesn't have to wait helplessly. He can protect himself. So, on the other hand, on the part of the debtor, he can recover whatever he paid by mistake before the condition happens. This is because at that stage, the obligation is still uncertain. If he pays too early thinking the obligation is already due, he can take it back. That's called solution indebiti or undue payment. So Article 1188 make things fair for both sides. So it prevents the creditor from losing his rights, and at the same time, it prevents the creditor from unfairly enriching himself if the debtor paid too soon. And lastly, we have the Article 1189, the loss, deterioration, or improvement, which deals with what happens to the thing involved in the obligation if something happens to it while waiting for the condition. So this applies when the obligation is a real obligation or to give something, the thing is a specific or determinate, the obligation is subject to a suspensive condition, the condition is fulfilled, and the thing has been lost, deteriorated, or improved during the waiting period. So in this article, there are rules. The first one we have is, if the thing is lost without the debtor's fault, the obligation is extinguished. No one is at fault. 2. If it is lost through the debtor's fault, he must pay damages. If the thing deteriorates without fault, the creditor bears the impairment. Number 4, if it deteriorates through debtor's fault, the creditor has two choices: either assign the obligation with damages or demand fulfillment also with damages. 5. If the thing is improved by nature or by time, the benefit goes to the creditor. And lastly, if it is improved at the expenses of the debtor, the debtor only gets the rights of a usufructuary, meaning he can enjoy the improvements while in possession, but he cannot demand reimbursement. So example, if X promises to give his car to Y, and if Y sells his house, and while waiting, the car gets destroyed by a typhoon, the obligation is extinguished because X is not at fault. But if X wrecked the car due to negligence, then he must pay damages. The law here balances the interests of both sides. The debtor is protected if he isn't at fault, but the creditor is protected if the debtor is careless. So to summarize, from my own understanding, Article 1186 prevents obligors from taking advantage of their own actions by treating the condition as fulfilled if they purposely block it. Article 1187 makes obligations retroact to the date they were created once the condition is fulfilled. Article 1188 protects both the creditor and debtor while waiting for the condition. And lastly, Article 1189 provides clear rules on what happens if the object of the obligation is lost, deteriorates, or improves before the condition happens. So in short, this article show how the law ensures fairness and balance in conditional obligations, protecting the rights of both creditors and debtors.
Good day everyone, I am Catherine T. Fernandez, and today I will be presenting Articles 1190 to 1192 of the Civil Code of the Philippines. These provisions deal with resolutory conditions, bilateral obligations, reciprocal obligations, and the remedies available when parties breach their contracts. At first glance, this may seem technical, but if we break them down with simple examples and applications, we'll see that these rules are actually very practical. They are designed to ensure fairness and protect both creditors and debtors in contractual. So let's start with Article 1190. So for Article 1190, the resolutory conditions, this introduces us to the concept of the resolutory conditions. An obligation is subject to a resolutory conditions when it continues to exist for now, but will be extinguished once a certain future and uncertain event happens. For example, imagine I lend you my laptop with the conditions that once the school year ends, you must return it. So the obligations to let you use the laptop exist while the school year is ongoing. But once the conditions, which is the end of the school year, arrives, the obligations is extinguished. So the general effect of a resolutory condition is that both parties must return what they received. It's as if the obligation never existed. The law calls this the principle of return to status quo. So, however, there's an important exception. If the object of the obligation has already been transferred to a third person who acquired it in good faith, it can no longer be recovered. This is meant to protect innocent third parties who relied on the contract in good faith. For the Article 1190 cont, now let us apply these different types of obligations. First, obligations to give. The general rule is that their effects are retroactive. This means that once the resolutory condition happens, everything given under the contract must be returned. A simple example is if you borrow a car for use until your CPA exams results are released, then once the condition, the release of the results, happens, you are bound to return the car. But there are exceptions. If it is clear from the agreement that the benefits were intended to be permanent, then there is no need to return them. For instance, if your parents agree to give you 1,000 pesos every month until you pass the CPA exam, then once you pass, you are no longer entitled to receive more money, but you do not have to return the allowance already given. The next is the obligations to do or not to do. In these cases, the law gives this discretions to the courts to determine whether retroactivity should apply. Why? Because in many cases, it will be unfair or impractical to require one party to return an act that has already been done, such as tutoring sessions or construction work. Therefore, the courts are tasked to decide in the interest of fairness and justice. So for Article 1191, the bilateral obligations, in unilateral obligations, only one party is bound. Like in a pure donation, for example, if I donate money to charity, the donor is bound to give while the donee has no obligation in return. In contrast, a bilateral obligation is one where both parties are bound to each other. Each party becomes both a debtor and a creditor at the same time. For example, in a contract of sale, the seller is the debtor of the goods, but the creditor of the price, while the buyer is the debtor of the price, but the creditor of the goods. So, bilateral obligations can be classified into two: reciprocal and non-reciprocal. Reciprocal obligations arise from the same cause and are dependent on each other, while non-reciprocal obligations are separate and independent. So for the reciprocal obligation and remedies, let's focus on reciprocal obligation first. In this obligation, the cause of the one party's obligation is precisely the performance of the other party's obligations. For instance, in a contract of sale, the obligation of the seller to deliver the goods is based on the buyer's obligation to pay the price. If one fails to perform, the other may rescind the contract. On the other hand, non-reciprocal obligations are independent. For example, a landlord may be obliged to repair the apartment building while the tenant is obliged to pay utility bills. These duties do not directly depend on each other. So one's failure does not automatically justify the rescission of the other's duty. Now, what happens when a party fails to comply in reciprocal obligations? The Article 1191 provides two remedies. Number one is the specific performance, which means compelling the other party to fulfill their obligation, plus claiming damages if there are losses. So number two is the rescissions, which means canceling the contract as if it never existed, also with damages. It is important to note that rescissions under Article 1191 is different from rescission under Article 1381. Article 1191 rescission is based on breach of contract, while Article 1381 rescission is subsidiary and usually based on issues like fraud or damage. So for court's role and limitations, when one party fails to perform, the injured party can go to court to demand either fulfillment or rescission. The court may grant the guilty party more time to comply if the delay was not intentional and its performance is still possible. However, if the guilty party outright refuses to perform, the court cannot grant these extensions. Another important point is that the remedies are alternative, not cumulative. This means the injured party must choose between fulfillment or rescission. They cannot demand both at the same time. For example, the buyer cannot demand delivery of the car and at the same time cancel the contract. But if the delivery becomes impossible because of the seller's fault, the remedy of fulfillment is converted into rescission. There are also limitations on rescissions. First, rescission must generally be judicially invoked unless the parties expressly agreed that rescissions will be automatic. The second is rescission is only available for substantial breaches, not minor or trivial ones. The breach must defeat the very purpose of the contract. The third one is the rescission cannot prejudice third parties who acted in good faith. And lastly, the right to rescind may be waived either expressly in contract or impliedly through the conduct of the parties. Finally, let us move to the Article 1192, which deals with cases when both parties are guilty of breach. These provisions ensures fairness by preventing one party from taking advantage of the other, especially when both are at fault. There are two scenarios here. The first one, if it can be determined who the first infractor is, then that party is liable. However, the court may reduce the damages considering that the other party was also at fault. So the second, if it cannot be determined who was at fault first, then the contract is simply extinguished and each party bears their own damages. For example, imagine a seller delivers goods late and the buyer also pays late. If it's clear that the seller was the first to default, the seller is liable, but the court may temper the damage since the buyer was also at fault. If it is impossible to know who defaulted first, then the contract is cancelled and both sides must must shoulder their own losses. So to summarize, Article 1190 tells us that resolutory conditions extinguishes obligations usually with retroactive effect. Article 1191 explains bilateral obligations, reciprocal obligations, and the remedies available in case of breach. Article 1192 clarifies what happens when both parties are at fault. So the common thread in these provisions is the pursuit of fairness and balance. Obligations are enforced, but at the same time, the law protects both sides and ensures that no party is unjustly enriched or unfairly burdened. And that concludes my presentation on Articles 1190 to 1192. Thank you very much for listening, and I hope these discussions gave you a clearer and deeper understanding of how these rules apply in real life.